In the April 4 election, Wisconsin voters overwhelmingly approved two constitutional amendments that change the factors that judges may take into account when making decisions about granting cash bail. If you're a criminal defense lawyer, how will the amendments affect your practice? And are the amendments likely to achieve the policy goals advocated by their proponents? Hello, I'm Jeff M. Brown, legal writer with the State Bar of Wisconsin. I'm here today with Brian Dimmer, criminal defense lawyer in Racine. Welcome, Brian.
Hey, good morning. How are you?
Doing well, doing well. Thanks for taking a moment from your busy day to explain these amendments to us and talk about some of the implications. Can you walk me through the specific changes that each of the two amendments made to the Constitution?
Yeah, and honestly, the changes are in some ways similar here. And I'm gonna kind of start with even reading the ballot language because I think that it's helpful here. Our question one was conditions of release before conviction shall section 8 sub 2 of Article 1 of the Constitution be amended to allow the court to impose on an accused person released before conviction conditions that are designed to protect the community from serious harm. Walking through this one particularly, this one I think maybe is a lot easier for I think a defense attorney to kind of swallow, because what it kind of does is it addresses some kind of limiting language in the old statute, the old Constitution that talked about bodily harm, and kind of removes that so that the court can kind of consider really what we think of as just harm without it necessarily needing to be bodily harm. The easy example, I think, at this point is there's certainly lots of crimes that might be considered harmful that don't involve a bodily injury. You think of maybe sex crimes against children. So you consider a person being released after being accused of a sexual assault against a child. Now the court might be able to include some sort of prohibition that bars that person from having contact with anyone under the year or age of 18. In the old law, technically, that wouldn't be allowed unless it was, based on something else, because the language said serious bodily harm. So now it's a little more generically worded, gives judges more discretion, more tools. Second one, and this language is a little more wordy, but I still think it's worth just reading out. Cash bail before conviction shall section 8 sub 2 of Article 1 of the Constitution be amended to allow the court to impose cash bail on a person accused of a violent crime based on the totality of the circumstances, including the accused previous convictions for a violent crime, the probability that the accused will fail to appear, the need to protect the community from serious harm and prevent witness intimidation, and potential affirmative defenses. This has a much bigger effect because the old Constitution and the old statutes more or less limited the court to saying, I can only impose an amount of cash necessary to assure that individual's return to court, which is really kind of a straightforward question. How much money do we need to put on the line so that Joe defendant ends up coming back for each of his court dates? Most importantly, the jury trial, or the part where the case resolves. Now the courts can say, well, this person is accused of a violent crime, and we think this person might be a danger to the community. And so, irrespective of how likely they are to come back to court, we are going to make that person put an amount of money on the line that says, hey, you're going to post $10,000, and if you screw around, you do anything to the community here, you're losing that money.
So it sounds like before, maybe I'm just thinking 1,000 versus $10,000 to keep it easy math wise, because we're lawyers and most of us got into this because it involved words, not numbers, right? So before, maybe the 10,000 would be reserved for someone who was wealthy, because 10,000 was what it would take to get their attention and impress upon them what they would lose if they didn't show up for court. But now you're saying it's going to be possible for a judge to impose $10,000 cash bail on someone who maybe isn't wealthy, not because it's more or less likely to make them show up for court, but because of the potential that the judge finds for future dangerousness. Is that accurate?
Yeah, I mean, it is. It's maybe I would say it's accurate, but I think that the in some ways in practice, judges or commissioners already, in my experience, um, maybe don't look at a person's financial means when setting bond anyway. For instance, it would be really, I think, helpful and maybe more, say, efficient if a judge knew what a person's assets were, so that that judge could know, well, is the $1,000 90% of this person's financial assets? Because we talk, like you said, $1,000 versus $10,000, and yes, what you're saying is true, but the other flip side of it is what this is really doing is giving judges more reasons to impose that $10,000 question, irrespective of whether that person is wealthy or impoverished. Gives them more reasons or more ways to justify that.
How are these two changes going to affect your day-to-day practice and the day-to-day practice of criminal defense lawyers, and even for that matter, prosecutors?
Yeah, I thought about this a lot preparing for this because I've got probably undergraduate professors who are going to love me for this, but I'm going to make a shameless plug for the sociologist C. Wright Mills, who talked about the what was called the sociological imagination, which is basically the ability to envision how one change affects a bigger, basically, world or the world around you. So, the easy, obvious effect is, well, more of my clients might be in jail, because if we're now able to impose cash bond in more situations, that means more people might end up being in jail. Well, there's a couple things that flow from that. First one is we have, as our Wisconsin Lawyer magazine was writing or wrote this current month, a lot of pressure on the criminal justice system right now. There are underpaid prosecutors, underpaid public defenders, underpaid private bar people who take those kind of cases, a post-COVID backlog. So we have already a lot of pressure on this system and limited resources. But what happens when you start locking people up is you trigger more pressure, because now those people are entitled to speedy trials. And all of a sudden now you're trying to figure out, how are all these trials going to happen? In my own personal life, I have a case in one of the counties around my office here down in southeast Wisconsin. The case has probably been kicked out or adjourned, say, 3 to 5 times because a trial's going on, meaning you're creating backlog to add to the backlog. So that's one of them, is you're going to create more pressure on the system and also create more backlog. I guess selfishly, as a private practitioner, if you're making people pay more for their bond, they have less money to pay for a private attorney. So in theory, that would affect, the people who might come to my office. But I think the bigger, what I'll call the sociological imagination side of this is, if there are less people who can afford an attorney, where does that put the pressure on? The exact same things we've already been talking about, which is the public defender's office, private counsel who are willing to take those cases. So you create more people who are less able to afford private counsel. Who pays for that? Well, the state of Wisconsin, and all of our taxpayers pay for that.
So it sounds like there's a bit of a yin and yang going on here. Let's say the legislature were, God willing, to completely fund the governor's request for the public defenders and the district attorneys, all of those requests that are talked about in that Wisconsin Lawyer article. That would lower the problem. And then to hear you tell it, this might actually undo what the legislature did under that scenario, because it's putting it's working a competing pressure.
Yeah, I mean, I guess I would say this: the if it gets passed, you might have a situation where there's a yin and a yang balance. But if that doesn't pass, you're basically shoving a crisis, even closer to crisis. And that to me, that's concerning because, as that article kind of writes, at some point the bill's going to come due. And the, from the defense practice perspective, I think, really this affects personally me, not as much as it affects those individuals who, and I'm going to bring it back to the story I was telling you before we started. My client whose case was recently resolved, I saw him in court maybe 3 or 4 times while handling other cases, waiting to get a public defender, waiting for somebody to be assigned to his case. And I just had this, like, I couldn't take it anymore. I was tired of seeing this guy waiting for an attorney. And I told the court after, I said, I'm happy to take this case on so that this young man has an attorney. Because I'm just sick and tired of hearing that 800 people have passed on his case. The case is, 8 or 9 months old. The flip side of that, though, is judges sometimes will say, well, this case is 2 years old. When is it finished? And I might say, well, Your Honor, I've only been on that case for 2 months. And they say, I'm sorry, it's 2 years old. We got to get this case over. So, these pressures do have an effect on everybody.
Regardless of what effect it has on that backlog and the criminal justice funding and stress issue, we'll call it that, regardless of that effect, how likely do you think these amendments, the adoption of these amendments, is to achieve one of the stated policy goals, which is to, remove the situation that's happened in a couple high profile cases last year where a defendant out on cash bail commits a violent crime? How likely are they to ameliorate that, do you think?
Sure. I think it's always said, the bad cases make bad law, right? So a critic would say, well, every time we have a terrible thing happen and we react to it, we sometimes, think we're doing good or doing, what we're supposed to do. Here, though, I think one thing I would say, as far as in effect, is what judges are already doing just becomes more transparent. So I think a seasoned criminal defense practitioner or prosecutor would know judges in some ways already are kind of looking at these issues. It's just now they're actually given the green light to look at those issues. So maybe less of it's sort of folded into other factors the court might consider. We read especially the question 2 regarding violent crimes and totality of the circumstances. I mean, I can't count the number of cases where my client has just about every reason on earth to stick around in town: job, family, kids, health issues, all sorts of things. And the court will, notwithstanding that, still impose this mighty bond based on, the seriousness of the offense. I'll hear those words, and that's kind of a veiled way of trying to say, well, such a serious offense, they might not come back. But what they're really saying is, this is a pretty serious case, so I'm going to impose a lot of cash. So, I think that as far as achieving the ends, I don't know that there's necessary, you're always going to have a situation where, somebody who you didn't expect to be a risk, or, somebody who a bond was set at some amount but was able to post it, is going to go out and pose some risk to the community. I mean, at the end of the day, and we'll go back to balancing, it's if we live in a society where people are presumed innocent until found guilty, we by that very virtue and principle accept that there is going to be some risk that some of those individuals are going to commit some crime while awaiting trial. And I think lost in the shuffle is, are those people committing crimes at a higher rate than just the average person? Because if not, then why are we spending all this time and money trying to regulate those who are awaiting trial when they don't really commit violations of law at a higher rate than those who are not on trial at all? So I guess my, really the takeaway is, one, I think judges are already kind of doing this. I think now it's just a little more transparent. Two, most research I've read shows that there's little or no real relationship with the amount of money you post and your likelihood to, reoffend. I mean, if anything, it just means that more people who don't have money are going to be locked up. Um, and then at the end of the day, I think the sad part about it is, as I said, we're really not getting a lot of benefit out of this. Boy, we're really putting some, unintended pressures on an already pressured system.